In this video, we're going to look at patent infringement. A lot of people get into patent trouble, and even if they don't, a lot of people are really worried about what happens if they do end up infringing someone else's patent when they launch their new product. According to some studies, up to 30% of all R&D work is duplicate, so the chances of launching something and then finding that actually someone else has already done it are quite high. But as you'll see from this video, there's lots of ways to avoid it, and I'm with Vicky from Pure Ideas, who's a chartered patent attorney who is going to help us navigate this complex world of patent infringement. Make sure you keep watching right until the end of this video, because we're going to help you avoid getting into infringement hot water in the first place, and also by then you'll know exactly what to do if you do end up in patent trouble. Let's imagine a scenario then. I've got a letter through from someone saying that my new product that I've launched, let's say it's a pushchair because I launched one 5 years ago with John Lewis, so it's a relatively relevant example. And I guess I somewhat lived in fear that I would get a letter from a big brand saying, you've launched a pushchair and you infringe on our intellectual property, you've got to stop selling your pushchair. So that's the scenario. What do I do, Vicky?
The thing to say is don't panic. Just because you've had a letter doesn't mean that there's an enforceable sort of court action at the end of it. The first thing you need to do is, I say this a lot, but find yourself a patent attorney and get some advice. It may be that you don't have a problem after all, and they can guide you through that. And if you do have a problem, we'll tell you the best way to get around it.
So it's not all panic stations. It might not end up with some court battle and me having to withdraw my product. Am I right in saying that in most scenarios it doesn't ever get to that, and there are things and methods that you're going to talk about that mean we can avoid those horrible circumstances that no one wants?
Absolutely. Even the person who has a patent is going to be reluctant to try and take that to court, because there's never, however strong you think your patent is, there's never a guarantee that you're going to win that case at the end of it. There are always arguments that your product doesn't fall within the claims, and there are other defences. For example, that there may be other prior publications that could invalidate that patent that they're trying to enforce, and they ultimately don't want to lose their patent. The vast majority of these situations will end in some kind of resolution. Sometimes you can make them go away altogether. Other times there may be some money to be exchanged or some exchange of technologies to resolve it, but very rare to end up in court with all those costs attached.
Okay, that's reassuring as a starting point. So talk me through invalidating the other person's patent, because it sounds like that's a potential line of defence.
Definitely, yes. So the first thing we'll do if you've got a letter and someone's asserting a patent is to actually look on the patents register and make sure that is actually a granted and enforced patent, because sometimes it may just be a patent application, in which case the claims that they're relying on for a potential infringement are yet to be concluded, so they may not be the claims that are ultimately granted in the patent, so they might not be enforceable. Another thing to look at is, have they paid their maintenance fees over the years? So if this patent is a few years old, they would have had to have been paying a regular fee to the patent office to keep that in force. They might not have done that. The patent could have lapsed, in which case you're free to carry on. So that's the first thing we do. If we end up in a situation where we think, yes, potentially they have an argument as to what your product does in relation to their patent, then we look in a bit more detail at the file wrapper, and there will be some language in there which could have a very specific legal construction based on admissions they might have made during the examination process, or documents that have been cited against them that they've argued around along the way. We may be able to argue a narrower scope of their patent in any event, which would leave you outside of that. And then what we also obviously do is do a comprehensive search for other prior publications. The patent offices are pretty good, but there's an awful lot of published material out there. It doesn't just have to be a patent publication. It can be an article, it can be a conference paper, it could be a video, it could be somebody's testimony that they were told this in a pub without a confidentiality agreement, all of that. So we would look at that, we would look for any prior publications that might be relevant, and then we do an assessment as to whether the claims that they are relying on to embrace your product are actually valid. And then there are subsequent opportunities for us to proactively challenge the patent, or alternatively, as you've said, if it comes to it in a court situation, we can use that as a defence. But of course, along the way, more likely what you're going to do is to discuss this with them and say, we have a good case here for challenging the validity of your patent. I'm sure neither of us want that. How about you give us a free licence to carry on doing what we're doing, and we'll keep these in a desk drawer somewhere and we'll never use them against you. That sort of thing could be the answer.
Okay, so it sounds like you could end up with some kind of legal deal whereby
Absolutely.
you can use what may or may not be protected by their patent
Exactly.
in exchange for you not revealing something that might invalidate their patent altogether.
That's right, because if you successfully challenge their patent, then they've lost their patent altogether. They can't enforce it against anyone ever again, and there's still licensing opportunity in it as long as it's granted. Somebody might be prepared to pay them a small fee to be able to do various aspects relating to that technology.
Okay, and so if we can't get an agreement where it's all okay to continue trading, you talked a little bit earlier about maybe we fall back to a point where we would pay them a license fee to use their intellectual property but in our product.
Absolutely. I don't know if you're familiar with patent trolls as a term. You might have heard of them.
I have heard of patent trolls. I don't know what they are, so it'd be good to
or
cover that.
Non-practicing entities, as they prefer to be called. These are companies that essentially collect patents so that they can raise them with potential people, and their main goal is to obviously generate revenue from those patents, so that they're looking to essentially find people using these technologies and to get licenses from them. Okay. So there'll be situations where you've got a direct competitor, they don't want you moving into the same space as them, they may not be willing to come to any kind of commercial resolution, but a lot of the time they may work in different sectors, or they may actually be seeking to generate income. Then you're in a much better position to negotiate some kind of a license fee to carry on, because you both win in that situation.
Okay, so this original scenario that sounds awful, you get a letter, which I guess is a cease and desist letter, basically saying you will cease selling the product because you're infringing our IP, maybe isn't quite that bad after all.
Yeah.
So let's just recap. We can potentially invalidate their patent application and threaten to invalidate their patent application unless they give us a license for free to continue to trade. Yeah. We can check that their patent's actually valid and they've actually got some kind of a case, because it sounds like there's quite a lot of hoops they would have had to jump through before they can actually enforce their patent against us anyway. Yeah. And then if all of that's failed, then we're potentially in a situation where we're saying, okay, we'll pay you a royalty fee to continue to sell our product for using your intellectual property.
That's right.
Okay, that sounds like there's quite a long way to go between that initial kind of letter and actually having to withdraw the product from sale. Yeah. Okay, and is there anything else we can then do if all of that's failed?
Your patent attorney can help you with this. Are there tweaks you can make to your design which would remove a specific feature that you don't really need in there, that would avoid the claims of the patent, so you can potentially improve your position then. It's a bit of a balancing act as to whether that's worthwhile. It may be very costly to do that. You may lose a lot of technical benefits of your product if you do that, so it's not always desirable, but it's always worth contemplating at that stage whether you can do it. And then if you're in a situation where you can quite easily, comfortably make that change so that any products you're selling going forwards fall out of the scope of the patent, that can often be enough to make the problem go away in itself. They may try and pursue you for past products that you've already sold, but again, you can say, come on, I didn't know about this at the time, we've changed the design going forwards, we're not a problem to you anymore, and you can try and work and come to some kind of resolution from that.
Okay, so that's not desirable, as you say, because it could result in new mould tools or changing a production setup.
Yes.
But if it's that or withdraw the product altogether, then that might still be an option that's worth considering.
Absolutely, yeah. Always think about it, but straightforward legal advice is saying, stop doing what you're doing. But that is a big decision particularly for an SME that's invested a lot, as you say, in equipment and that sort of product design.
Yeah. So I guess if we applied that to the pushchair example, we've got some clever wheels on there that we've got some IP protection on. If someone had come and said, actually, you're infringing our patent on this particular shock-absorbing wheels, we could have just said, okay, we'll drop that as a feature, we'll put some standard wheels on it, and then we'll sell that product instead.
Yes, definitely that would be it, if that worked for you in terms of your product and what you were marketing. If you've got other features to promote, then that would be a good solution to your problem.
Yeah, I guess we're quite lucky in some ways with the pushchair. There's 5 or 6 different unique features, so I guess we just reorientate our marketing. Obviously, we'd have to do new photos and video for social media and all that kind of stuff, so it would not in any way be a small change, but it would have obviously been better, as I say, than withdrawing it all together and losing all the value of everything we've developed.
Absolutely, and that's why we look at all these other options in parallel with that as well, because it's not always the best solution, commercially speaking, although it is probably legally speaking to just make the problem go away.
And I think that's probably one of the main things to take from this, is that it is a commercial thing, and that most people who hold patents want to make money out of them one way or another. And so actually most people won't go down the court route because that's going to cost them money. They'll instead say, let's come to an agreement here, even if they start off quite aggressive with their negotiating position. Often it is just a negotiating position that they're trying to get into.
Absolutely.
Because they want to make some money off what they spent quite a lot of money investing in terms of the patent application.
Yeah, of course. When it comes to court cases, there's a lot of uncertainty involved at the start as to what you're going to get there. Even if you win some kind of damages award at the end, just your costs of all your legal professionals and all the court fees and everything else can be very significant. So you could still end up out of pocket at the end of it and potentially lose your patent or lose your case and end up having to pay the other person a proportion of their fees. So nobody really wants to go there unless it's absolutely necessary.
No, indeed. Now, obviously, the ideal scenario would be to avoid ending up in this situation at all.
Yes, definitely.
So can you just tell us a little bit about what we can maybe do to avoid ending up with the risk of infringing on someone else's intellectual property?
Again, talk to a patent attorney. We can do what's called a sort of freedom to operate search. So if you've more or less decided what your design is going to look like before you start investing in all of those manufacturing tools and everything else, we can do a look, see what's already out there, what existing granted patents are in force, also how long they've got left before they expire, because a patent has a maximum of a 20-year term. If you're in the 18th year, then it may still be worth going ahead. Yeah. And we can give you some advice from there as to if you just change this small aspect of your design, that would avoid this particular problem and give you an idea of what the sort of risk profile looks like in terms of if you proceed with a particular design that you have in the face of what the granted patent landscape looks like.
Okay. And we should say that if someone wants a free consultation with you, then there's a link in the description below and you can talk them through for their specific project, how you'd approach it and costs and all that kind of thing.
Absolutely. Anything related to your IP, and we'll have a quick chat with you about what your situation is and give you some ideas about what we can do to help and what that might cost.
Cool, that's great. Equally, you can put a question in the comments section and we'll try and respond to that and answer your questions there as well. You've just mentioned freedom to operate searches. Now, I've been involved with patent searches previously, but they're normally just novelty searches. In my understanding, freedom to operate search is actually pretty expensive as an option.
Yes. Yeah, it certainly can be.
Right.
It's a question of just how sure do you want to be that there isn't an issue. So to do a completely thorough job, we would want to look at every small aspect of that product that you're doing to be the new concept, because there could be older patents covering everything from the smallest fastener that you might have just bought off the shelf to use through to the idea itself that you've embodied in your product.
Okay, yeah, and I think I've heard scary stories of people like Kellogg's spending £30,000 on freedom to operate searches and that type of thing.
Yeah, you certainly can spend that much money, and it's not just for doing the search. There's also a lot of analysis involved. So every single patent that you find that looks potentially relevant, then your patent attorney would need to do a thorough analysis of that against your product to determine if it is or isn't a problem. The more of that work you get done, the more assured you can be of how good or bad your position is. But if you're on a sort of a limited budget, then say, look, I've got this much to find out. You can certainly get some level of understanding as to what the situation looks like for a smaller budget. So,
yeah, that's really helpful.
Yeah.
So I guess it's like a sliding scale, isn't it? You can spend maybe £600 or £700 on a novelty search, and you'll probably find any knockout examples in terms of existing stuff, but you're not going to find everything because there just isn't the budget there to spend the time looking through absolutely every patent and registered design and everything else you might want to do. So it's reduced your risk a lot, but you could spend £30,000 and reduce your risk more.
Yes.
And it's
exactly.
a question, I guess, then of how comfortable you are with the risk you're taking.
Yeah, I think it really comes down to how valuable is this product to you, how big is the business you're likely to generate from it, and weigh that up against how much certainty you want to invest in looking at the risk situation. It's always a good idea to do some kind of search. We can do top level ones where we'll just give you a bit of a competitor landscape and flag up areas where they're quite densely populated in terms of patents, so you can at least have an awareness of where you might run into problems. And then if it looks like it's becoming a problem down the line, we can focus in on that sort of narrower area and give you more focused advice on that particular risk.
Yeah, no, that really helps. And I think it's worth saying that from my experience working on hundreds of projects with startups and entrepreneurs, I don't think any of them, bar one or two, have ever had a cease and desist letter. So I think a lot of people are worried about it, but actually it doesn't occur very much. But maybe that's because we do the novelty searching. We are very aware of what competitors are already doing in that space and that type of thing to try and avoid it. But I guess what I'm saying is it's not something that should keep everyone awake at night, but there are some steps you can take to reduce your risk in that area.
Absolutely, yeah.
Okay. And I guess the final point to make is that even if you do end up infringing, as we've heard from your very helpful advice at the beginning, actually it's not the end of the world. There's a whole process you can go through, and the right thing to do obviously is to get in touch with someone like yourself, a chartered UK and European patent attorney, who can then go through those steps and try to get a good outcome, a commercial outcome that means you can continue to sell your product.
Yes, absolutely. Good advice.
Fantastic. Now we've got another video. We think you're going to love it. It's all about the patent application process and the tips and tricks that you can take from that. So do make sure you check out that one straight away.